electronic device in silent mode to access any materials that have already been downloaded onto the device. However, if you wish to use an electronic device to aid in your presentation, Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Hey, Mark. Do you want me to? Okay, good morning, everybody. Welcome to the United States Court of Appeals for the Fourth Circuit. I was trying to see if our vaunted and trusty clerk could somehow change this from a bat cave to a little bit more lighting, but we'll work on that. In the interim, I guess we'll make do. We have three cases on for hearing this morning. The first is 23-1880, MP versus Meta Platforms. Mr. Mandich. Yes, please.
Thank you, Your Honor. And may it please the court, my name is Mark Mandich, and I represent the appellant in this case, MP. Apologize in advance. I'm getting over a cold here, but I'll try to, that's my battle. So there are a number of issues in this case. I'd like to start with 230, and I think that's where my focus will lie unless the court cares to hear otherwise, but we'll get to whatever we can. So beginning with section 230, it was Meta, not third parties, who designed a product to hack and exploit a weakness in the human brain in order to mine attention. It was Meta's decision to do so without any safeguards or concerns for the myriad ways this can be harmful to consumers, ways we've seen in recent years, including the youth mental health epidemic that's ongoing, radicalization and polarization, which is something we're here about today, and facilitating trafficking, child sex trafficking, and terrorism. It was Meta that created recommendation algorithms concerning content, friends, and groups. It was Meta who decided to design these algorithms in such a way that they inherently promoted negative emotion-inducing content and content that was polarizing, violent, shocking, upsetting, whatever terms you may choose. It was Meta that decided to design these algorithms to induce chemical changes in the brain. It was Meta who ignored the calls of its own insiders and employees to fix its algorithm or moderate its policies because its product, as designed and placed in the market, was inherently dangerous, in particular in its tendency to drive negative emotional responses and to elicit what its own insiders have termed emotional contagion. These are our allegations against Meta.
Well, let me ask you about those, because they might well be very compelling allegations in terms of broad critiques of these platforms, many of which I think deserve the criticism, but we're focused on this case and how these platforms, if at all, were a cause of the horrific crimes that Mr. Roof committed in Charleston, South Carolina. And I think that's where the concern I have is that the link that you were attempting to make in the complaint just doesn't seem to be there. So maybe you can focus on that, in addition to the fact that you've got to overcome the congressional policy with respect to 230 and limitations on suit that certainly it appears that Congress intended to eliminate on facts similar to the ones you've alleged.
Certainly, Your Honor. So I'll start with the fact side of that and then circle back to the law. So admittedly, our claims and facts regarding Dylan Roof and his Facebook interaction rely a lot on inference. And here's how we get there, okay? We know that Dylan Roof had a Facebook page. We know that he curated in terms of his number of friends, such as to demonstrate his allegiance to white supremacist ideology, and that he felt comfortable enough to post pictures of himself in white supremacist symbolism, Rhodesian flag and things of that nature. His now infamous Google search was 3 years prior to the attack on the church in Charleston. We know that Google and Facebook share data. We know that Facebook would have been aware that this type of content was something he was interested in and would keep him engaged and would be a powerful driver of his
Do
engagement.
we know that, or are you just speculating about that?
Well, we know the way Facebook's algorithm worked, and if he
Well, we know
Which
that
point?
maybe as a general matter, but I guess the problem is linking whatever Google and or Facebook were doing to the acts that were committed in this case. And then on top of that, and I apologize for digressing from your primary argument, which is the 230 issue. Even if all of that is true, how do you get around the fact that we have precedent that makes it, at least from my perspective, pretty clear that on these facts, there just isn't any basis for liability because Congress has told us so?
Well, so going to that legal point, which I guess is where you want me to go now. The recent decision by the Supreme Court in Moody versus Net Choice, followed up by the Third Circuit's decision in Anderson versus TikTok, has shifted the ground here. We now know that the recommendation algorithms that are used by companies like Facebook are their own conduct, their own content, their own speech. Anderson versus TikTok from the Third Circuit picked up on that and has now found that 230 is no bar to claims that are based on that conduct, Meta's conduct or other social media platforms or any internet service provider that over which you can make a claim that their recommendation algorithms played a role in the harm that occurred. And that is...
Can I ask you about, you just said recommendation algorithms. Would you be willing to maybe specify what algorithms you're challenging? Now, you don't know Facebook's internal materials. I'm not asking for that. But for example, in Force versus Facebook, the majority and the dissent seem to be drawing some fine lines based on news feed, where certain third-party user content was placed, as the majority saw it, versus recommendations. Judge Katzmann thought it was important that in some respects the algorithms went beyond just placing third-party content in certain spots for certain users, but they affirmatively recommended that a user join a certain group or befriend another person. And I'm looking at your complaint and trying to parse that and make sure that I know all the different algorithms, maybe not be the right term, but all the different results that you are challenging.
So friends, groups, content, the news feed, the groups you should join, the people you may know, we believe there's a reasonable inference that when Dylan Roof would have gone on to Facebook, based on how its algorithm works, based on the fact that he had been performing searches about black on white crime and spending time on the Council of Conservative Citizens website, that the Facebook group that Facebook actually self-generated for the Council of Conservative Citizens likely would have popped up. That otherwise his feed would have contained content that was polarizing in terms of the issue that he had searched on Google, black on white crime. The ins and outs, exactly how those dots connect in our case, no one knows that other than Facebook. So we're a little hampered there, and I'll admit that. I knew walking in that would probably be top of Your Honor's concerns. But we believe there's enough to raise a reasonable inference that Roof's engagement on Facebook would have matched his engagement on the internet more broadly. Other websites like Stormfront, known sites like that, Facebook's algorithm is geared to keep you on that site. If that's what he's looking at off of Facebook, then when he gets on there, they want to keep him there. They don't want him going back to Google. We want to keep you on Facebook. we're going to show him as much content as
Can I ask you a really specific fact question? There's a reference to the Discover results. There's like recommended for me and then Discover. What is that? Or can you tell me? I wonder if I could find it in the complaint. You say at paragraph 157, analysis by Facebook showed that 64% of all extremist group joins are due to our recommendation tools. This included Facebook's groups you should join and Discover algorithms. And I don't know much about these platforms other than what you plead. I just wanted to make sure I knew what Discover algorithm was, what it's doing.
I imagine, I'm not totally familiar with the Discover algorithm myself. This paragraph and what's detailed in there comes from studies and outside sources. But the Discover algorithm, I presume, has to do with search function. And
I'm just trying to see if there's a line to be drawn between affirmative recommendations, what we might say is speech from the platform versus third-party content.
Certainly. I think the more recent cases bear that out. I want to say Khalees versus Meta Platforms, or it might have been Bride versus YOLO. One of the recent Ninth Circuit cases made that distinction. I could be wrong about that. As you can see, I've got a large stack of cases, and they kind of all run together when you're reading. But if it was Bride versus YOLO, that's right. Where the recommendation algorithm played no part in the product defect allegation that the court addressed and said was properly pled only concerned anonymity. They acknowledged that that more broadly, that their holding is not saying that product claims or design defect claims are never good. They specifically addressed this one, and they declined to address the broader argument, which would include what we're saying. But yes, Facebook's role in recommending and connecting and matchmaking as opposed to simply publishing would be the crux of the matter. If he searched independently and found materials that he was already looking for, that would be a different story.
Can I ask you, you were about to talk about net choice and how net choice changed the landscape in your view, but I'm not sure that I agree with that, but I'm certainly amenable to being persuaded otherwise. So net choice was not a case about Section 230, but it was a case about whether or not the state, i.e. the government, could dictate to these social media platforms how they would curate the particular information that was being filtered through their feeds. And the court, first of all, decided that the courts below had looked at the issue incorrectly. It should have been analyzed in terms of a facial challenge as opposed to an as-applied challenge. But more importantly, they did say, and I'll concede this, that because social media platforms are engaged in expressive activity, that's a core First Amendment right, and state governments, in this case Florida and Texas, could not compel them or dictate to them how they would filter or curate the information. And that seems to me to be correct. But that doesn't at all, to my mind, suggest that Congress couldn't say, notwithstanding that they might be engaged in expressive activity, we're still not going to allow lawsuits based on the information that they gather from other folks and curate and send out via their algorithms to their users. So those don't seem to be inconsistent to me, but can you explain to me why you think they are?
Well, I think Justice Thomas, in his multiple dissents where he's calling for...
Well, it is a dissent. And so,
correct. Yeah. But, a point that he draws is that you can't have your cake and eat it too, essentially. Meta and other...
Apparently Congress said they could.
Our argument would be that, and I believe many of these courts, including Justice Thomas, agree, that these are not textual readings of 230. Isn't
that the premise of publisher liability? You're being held responsible for speech, and, we have to take into consideration net choice, but it doesn't seem inconsistent to say that net choice properly recognized this is expression, but then in 230 casts a very wide net that protects these platforms, even when they're expressing something, but because they're putting together other third parties' expressions, even if it involves their own First Amendment rights.
Well, I believe that's the change. In the 230 context, Meta has constantly argued in courts all over the country that this is not their content. This is not their speech. In the First Amendment context, you get a little bit of a different tune. But Section 230 on its face only prohibits treating them as the publisher or speaker of another's content, another internet computer service, IC, whatever the term is.
Why isn't that exactly, though, what's being done under your allegations? They're making decisions, their algorithms, as to what content to put in front of people. They're arranging information and putting it out there. Isn't that classically what a publisher does? It takes other parties' information and then decides how to market it, how to put it out there, where to place the emphasis. How is that different?
Well, I would point to Judge Katzmann from the Second Circuit in his dissent, which I believe Henderson and the Supreme Court and Justice Thomas, a lot of other courts have been picking up on. His analogy was very good. If you had a friend or acquaintance who said, hey, I've read everything you've ever written and read everything you've ever posted on the internet. I've also read everything that this other author has posted, and I think you two should meet. You might say your friend or acquaintance fancies himself a matchmaker, but would you call him a publisher? Have we ever known publishing in the traditional sense of the word to include such targeted direction of content? And that's where the Moody versus Net Choice decision comes in. It's now been proclaimed by the Supreme Court that that's their expressive content. That's not the expressive content of others. Now, to your point, and as I believe Henderson allows, we're not running from the content itself having impacted Roof. It certainly did. That's not what we're seeking to hold Meta liable for the content of a third party. We're seeking to hold Meta liable for their product design, the architecture of their system that would immerse someone like Dylan Roof in essentially an echo chamber of content that affirms his beliefs.
Well, excuse me, I didn't mean to interrupt, but their decision to put certain information and certain content in front of certain people, that's what you're going after, right? And see, that's what I'm struggling with. How's that different from publishing?
Well, I would point to, in addition to Anderson versus TikTok, the other supplemental authority we cited. And while it is a magistrate's report and recommendation in TV versus Grindr out of Florida, it is a very detailed and well thought out opinion that addresses, for my part and what I've researched, pretty much all of the arguments and the evolution of the case law and how we've moved away from what the purpose of 230 was, or what many believe it should have been, which is simply to ensure that internet service providers, like they were back in the days of AOL when Zoran was decided, would not be held liable simply for hosting content that they had no part in.
Oh, and I'm interrupting you again, but I think, isn't the issue really who fixes this? I mean, this is Congress's law, and how do the courts go about fixing it? I mean, if we have to take the words that were given and the reasonable construction of them and apply them in the arguably more modern context than the old printed word publishing business, but we're still, I don't want to say stuck, but we're still confined with the words that Congress gave us. And to me, the burden is on Congress to fix this, and the courts really can't fix it. And I think that a lot of the cases are expressing the frustration of the courts because it's a square peg in a round hole. In reality, maybe Congress never contemplated the reach of the Section 230 when they enacted it. But if there are going to be restrictions, don't they have to come from Congress?
My favorite iteration of that more recently was a four-dimensional peg in a three-dimensional hole, which I think fits the technological times we're in. But respectfully, no, Your Honor, I don't believe that Section 230 includes in its text the breadth of how it's been interpreted and used. And I believe Justice Thomas agrees, as do many other courts, Judge Katzmann in his dissent in force, that we've gone far beyond the language and the intent of Congress, which is, as I was saying, to prevent In order to allow this vibrant, new platform of free expression, it was important that simply hosting third-party content wouldn't get you on the hook for whatever is harmful about it. But it says nothing about anything beyond that. The text says to hold you liable as the publisher or speaker of third-party content. When you are yourself expressing where content should be directed, where I believe will be most interesting to most users, and using it in a way to garner more attention on your site, you've gone beyond traditional publishing and beyond the text of 230, certainly.
All right, thank you, Mr. Mandich.
Thank you, Your Honor.
Mr. Spencer?
Thank you, Your Honor, and may it please the Court, Jacob Spencer on behalf of Appellee Meta Platforms, Inc. Dylan Roof's horrific murders at Mother Emanuel are an unspeakable tragedy, but the complaint's attempt to hold Meta liable for that tragedy is barred under Section 230 by Henderson, Zarin, and other cases of this Court. What the complaint says in paragraph 167, where it is describing the alleged radicalization of Dylan Roof, is that Dylan Roof did not spend that much time on Facebook and was not particularly active with posting, but that time he spent on Facebook allegedly served as an affirmation of beliefs that he had acquired elsewhere. That theory of liability flows directly through the dissemination of allegedly improper content and is therefore barred by Section 230 under Henderson, and it also fails to state a claim under South Carolina or federal law.
Can you talk about the distinction that the Third Circuit made in the Anderson case between first-party speech and third-party speech? The panel there seemed to be persuaded that Congress in Section 230 never contemplated immunity for first-party speech in the context of platforms that go beyond simply being a repository of information and make conscious decisions as to what will or will not be included in a particular curation of that information.
Of course, Your Honor. I think the first thing I would say, as the Third Circuit itself recognized in Anderson, is that its decision is inconsistent with this Court's opinion in Zarin and with cases applying Zarin. So the Third Circuit departed from this Court's well-established precedent, which compels affirmance in this case. On that distinction, I think there are several problems with it, but the foremost one, to my mind, is everyone recognizes that Section 230 was enacted in part to overturn the Stratton-Oakmont against Prodigy decision, which had held Prodigy liable on a defamation theory. And the reason why Stratton-Oakmont held Prodigy liable was because Prodigy was not just a neutral, passive conduit or bulletin board, but because Prodigy exercised what it called editorial control, and it held itself out as a different type of website and safe for families because it exercised editorial control. And it was exactly that editorial control and the way that it was implemented through automated or algorithmic content moderation that caused the Court to treat Prodigy as a publisher of the allegedly defamatory speech that was posted on Prodigy's website. So to say that when a provider like Facebook engages in publishing activity, which is what this Court has held consistent with the text purpose of Section 230 is protected by Section 230, to say that that very activity is what deprives it of Section 230 immunity turns Congress's goal on its head and also is inconsistent with the plain text of Section 230. If you look at Section 230F4, which is the definition of an access provider, which is defined to be an interactive computer service provider. An access provider does things like pick, choose, filter, organize, reorganize, display, and forward content. So if those activities, if done in, if those publishing activities are under Section F4, what makes you eligible for Section 230 immunity? It would be a very surprising result if those same activities were also what remove you from Section 230 activity, because then it is your first party conduct. And I think that this court's case in Henderson lays out the very careful framework that applies directly to this case.
Does it, it seemed like the Third Circuit was also making a distinction, perhaps, between TikTok as a unique social media platform and perhaps others, in the sense that in that case, the 10-year-old child was, had her, and frankly, I'm completely ignorant when it comes to TikTok, and thankfully so, but she had her own page and a video was then promoted through that page. Is that, I guess what I'm asking, is TikTok any different from your client's sort of method of curating information, and does that matter?
I think, first, I would say it doesn't matter in this case, because this court in Henderson and Zarin applied, a well-reasoned test for Section 230 that covers this case. But there is a distinction between the TikTok case and this one. That was about what the court called a targeted recommendation. There's some discussion to concede in the complaint about some types of recommendations, but if you look at the actual allegations providing the speculative and minimal link between Meta's alleged conduct and Dylan Roof, that doesn't turn in any way on targeted recommendations.
Well, I wanted to ask you about that. I'm glad you mentioned it. Paragraph 89 of the complaint says that Roof was directed by Facebook, based on its algorithms' knowledge of his engagement on the internet, to groups and communities in which his views were cultivated, developed, made more extreme. What's your perspective on these allegations about recommendations to join certain groups?
Your Honor, I think that is the allegation in the complaint that suggests not only that he was directed, but that he found groups, and it itself turns on the content where his views were cultivated, developed, and allegedly made more extreme. So even that turns on the content.
I guess I'm wondering, is there a distinction? We have Zarin and Henderson that kind of very clearly lay out what it means to be acting as a publisher. But do they go so far as to cover recommendations? So instead of just you're being held responsible for someone else's content, you've put their content out there, but are these recommendations different? How does Facebook recommending that someone join an extremist group, how does that fall under our definition of publisher?
I think, Your Honor, the court doesn't need to reach that question in this case, because I don't think it's presented by the complaint, which is about white supremacist propaganda that Dylan Roof was allegedly radicalized by. The complaint says that at paragraph 5, at paragraph 6, at paragraph 7. And then at paragraph 62.
But let's imagine that the question I just asked is relevant, and that I think the complaint has allegations about recommendations to join groups. How do you think we should think about, how should we think about that in light of our precedent about publishing?
Absolutely, Your Honor. As the Second Circuit held in Force, and as the Ninth Circuit held in Dyroff, recommendations in the sense of where you display content, how you display content, making content more prominent in someone's feed, alerting readers to particular content, all of that falls within the traditional editorial functions that this court has time and again said are protected by Section 230 and not enough to take you outside the boundaries.
Is there a difference? And again, we might be wading into waters about social media that I thankfully don't know much about. is there a difference between, where content is placed? It happens to, the algorithm puts it on someone's news feed versus prefacing that with, we think you would like this group, or groups you should consider, where it's kind of an affirmative statement by the platform.
Absolutely. I think in the language of Henderson, what you are looking at is whether the service provider made a material contribution to the unlawfulness of the content. So you can imagine a recommendation that is itself defamatory within the plain text. This video you should watch because something negative, something defamatory that's in the recommendation. And that, I think you would say, could constitute a material contribution to the unlawfulness of the content.
Well, what about recommending groups?
Well, Your Honor, I think as Force laid out very well, recommending groups means recommending particular third-party content. So in the words of Henderson, if the claim turns liability is premised on the dissemination of some improper third-party content, then that falls within publisher activity as this court has defined it.
I thought groups were a little bit more about connecting people with other people. Now, then you can see the other people's content, but it's also making connections among people who share certain ideas, isn't it?
Yeah, and I think that's not quite precise. I think that groups are groups of third-party content. It's not recommending a person, it's recommending a person's third-party content. So even groups are about third-party content. But I think, again, if you look at paragraph 62, where the complaint specifies, it says that Roof radicalized online, and Facebook was a factor in that process. The things it describes in paragraph 52 are, first, by allowing white supremacist groups essentially unrestricted access to spread hate. So that's not about recommending groups, that's about not taking third-party content down. It also says Facebook also allowed Russian intrusion by allowing numerous fraudulent campaigns on Facebook. So again, not about a recommendation, it's about not taking down. And if you look at paragraph 98, that's where the complaint describes what it calls the design defect in Facebook. And the design defect is, allegedly, that Facebook's goal was to maximize engagement. That is, to publish, display content in such a way that people view that content. That's the traditional editorial function. And if you look at what they fault Facebook for, paragraph 195 says that Facebook had options to, quote, curb the spread of negative content. So again, about content. And paragraph 126, Facebook had options for moderating its algorithm's tendency to promote hate speech and misinformation. And in the paragraphs about how Roof was allegedly radicalized, what it ultimately says is that although Roof spent little time on Facebook, that time served as an affirmation of beliefs, which is necessarily about content. And I think that same reason why this falls within the heartland of traditional editorial discretion of a claim based on the dissemination of allegedly improper third-party content, so is barred by Section 230, is also the reason why this complaint fails to state a case or state a claim under South Carolina or federal law. And I would start with what was discussed in the previous argument, which is the lack of any but-for or proximate causal connection between Meta's alleged conduct and specifically the design defect alleged, which is a goal of maximizing engagement with algorithms, and Dylan Roof's horrific murders. The complaint itself says, this is paragraph 60, paragraph 166, that Roof began the radicalization process through a Google search, and that Google search led him to a different website for a white supremacist group called the Council of Conservative Citizens. And it acknowledges that he spent limited time on Facebook and was not particularly engaged with posting. The only specific allegation about Roof and Facebook is that Roof himself changed his profile picture on Facebook a few months before the shooting. That's not
And
enough.
then there's that paragraph 89 that I quoted to you, that Roof was directed by Facebook to groups or communities where his views were made more extreme.
Yes, Your Honor, I think that there's no allegation about any particular content he saw, any particular groups he joined, and under the Nemeth Chevrolet case, I think that those matter in assessing Section 230 and also the merits.
How would they know all that before they get discovery?
But, Your Honor, this is a somewhat unusual case, right?
You're going to say because the criminal trial.
It's both Roof's manifesto, which is cited in the complaint, and the criminal trial. And the manifesto.
But is that the standard? I mean, imagine that stuff wasn't out there and this was a less well-known person who had, caused some maybe lesser harm against someone. Plaintiffs wouldn't necessarily have access to all of their perpetrators' activities on Facebook, would they? And they have to make the best allegations they can, and our pleading standard acknowledges that.
Certainly, Your Honor, and I think two responses there. One is that as this court has held, you need a plausible allegation before you unlock the doors of discovery. So it's not enough to speculate and say we need discovery to confirm. And then the second is it's not that there's a lot of information out there and therefore they don't need to know more. It's that the information from the manifesto and from the criminal trial, which is incorporated by reference into the complaint, undermines any plausible connection, causal connection between any alleged conduct by Meta and the horrific murders. And I think beyond the lack of but-for causation, there's also a lack of proximate causation. And I think the case that is just squarely on point here is the Sixth Circuit's Crosby against Twitter decision, where it's almost identical recommendations. A young man, Omar Mateen in that case, who allegedly self-radicalized by viewing ISIS content online, and based on that self-radicalization from the content that was allowed to be in his feed, that was promoted to him, that was not appropriately taken down, he committed the Pulse nightclub shooting. And the Sixth Circuit in that case said there's no proximate causation here, in part because there's billions of people using social media.
Was there an allegation there that the algorithms were causing radicalization, or just that material was available and not taken down?
In a sense, the allegation was that the algorithm should have been changed to better identify and take down and remove these ISIS content.
So it wasn't an allegation that the algorithm itself is causing the harm by increasing the volume of negative content given to particular users.
That theory was not in Crosby. Of course, it was in Force, where the court said that it was barred by Section 230.
I thought the court said in a footnote that it didn't consider the radicalization point in Force.
What it didn't consider is the idea that they were designed to promote radicalization. But of course, the theory here, the defect is not that it was designed to promote radicalization. The theory is that the actual defect in this case is that the goal is to maximize engagement with third-party conduct. And then the complaint then says, polarizing divisive conduct tends to be more engaging and therefore is displayed more prominently in the news feed. I don't think that's a recommendation within what courts have been talking about Section 230. And I think that under Crosby and other cases, it certainly is not enough for proximate cause. And even if there were proximate, I guess I would say too, that if there's any sliver of this case that can evade Section 230, either because it's expressive activity or first-party speech, that's all the more reason, as the Sixth Circuit said in its James case, not to stretch the law of product liability to apply in that case. And here we have this court's decision in Lorenz talking about how you interpret South Carolina's statutory rule, which is the restatement of second of torts, says that the court should be cautious in expansive interpretations of that statute to make sure that the law of product liability does not become untethered from its purpose. And its purpose is products that are capable of causing grievous bodily injury. The theory in this case is about thoughts and ideas and expression, and courts have held time and time again, in James, in the Ninth Circuit's decision in Winter, that that theory of liability is not a product theory, which is a
could predict would be harmed.
Your Honor, it's undisputed in this court that the user or consumer applies to all of the product theories because South Carolina has said that negligent design has all the same elements as.
No, they haven't said it. I mean, you say that in your brief, but that's kind of a paraphrase in an opinion that says, you know, these three elements also apply. And when you look back at the three they're talking about, it's not the user or consumer language. And South Carolina's been pretty clear that user or consumer doesn't include foreseeability analysis that is included in the negligence claim, and that's part of the restatement too.
I think, Your Honor, even if you were to apply a foreseeability analysis, that as the Sixth Circuit concluded in Crosby, where it applied a foreseeability analysis to nearly identical claims, it's not reasonably foreseeable that someone who in this case is alleged to have spent limited time on Facebook would go on to commit one of the most horrific racial murders in modern American history. That's well beyond any natural and probable consequence of anything that Facebook allegedly did. I say I'm over time.
Thank you, Mr. Spencer. We're exceeding your time. It would take you a minute to get up here, so you probably, Mr. Bladeau, we'll hear from you, sir.
May it please the court. Francois Bladeau for the plaintiff. Traditional editorial functions. That's what we're really here about. That's what the law's about. That law was passed in 1996. Zoran happened in the late 90s. At the time, no one imagined the world that we're in today in regard to internet interaction and social community and those effects. My good friend, in his response to our appeal, noted or likened Facebook publishing as a newspaper that put up some image that was horrific in the paper. That's not what we're dealing with. Judge Rushing pointed this out. This company tracks everything you do online. It builds a profile on you, and then it sends material to you, both through its feed, news feed, what you see when you get on the site, and it directs you in a way to psychologically manipulate the biochemistry in your brain. I'm a surgeon as well as a lawyer. This is an area that I've spent a lot of time in. The issue is so far beyond any kind of traditional editorial function that the Communications and Decency Act, when it was passed, even thought of. They couldn't even imagine where we are today. When you go online and you...
That's not an unreasonable argument, Mr. Bladeau, but of course, Congress has had, they haven't been living in a cave. They've understood, I think, these policy arguments and have yet to take any action. So getting back to Judge Keenan's point, why are we in the best position to do that?
All right, because if you look at the progeny of cases, the initial thought process in Zoran at the time was appropriate. I think it was a proper type of legal analysis that was done. But since then, the blanket immunity that has been added, I think has gone too far. And what this court is really about today is, do we need to pull some of that back? If a company profiles someone and instead of just putting content out, actually has its own algorithm and its own product with a goal of pushing you into an echo chamber. And there's no doubt that online radicalization occurred in Dillon Roop. There's no fuss about that. Fact. In their response, they say it's just other internet companies that did it. What we know about the trial is Dillon.
Why isn't that publishing? I mean, it might be a very bad publishing practice, but you can imagine I know analogies to print are dangerous, but imagine, a magazine tracks every subscription you have, and they discover that you like bad ideas, and they want to send you a magazine full of bad ideas in articles that other people have written. They're publishing other people's bad ideas to you, and that's still publishing, even if it's irresponsible publishing.
Yeah, so display, alter, promote, monitor, delete content. Those are publishing. That's publishing. Trying to biochemically change your brain so that you spend more time on their site so that they can make money, that's their interest. That's their product. That's not the same thing.
How do they do that? What's the allegation for how they cause someone to spend more time on the site? Isn't it by giving them certain content?
It's by the psychological profile that they build, their algorithm that analyzes you and then feeds higher and higher and higher and higher levels of shock to you to trigger your brain to want to continue. And so it is and look, the science is coming out on this. There's no question that this is going on. And the problem here in this case, the other thing I want to address, I don't have much time left, is this argument that, well, we don't think he spent that much time on Facebook. What we know from the criminal trial is that Dillon Roop was a loner. He was a true lone wolf. And that time on Facebook and his posting photographs of him shortly before he acted, there's no question that his interaction with Facebook played a role in his determination that this was the truth. The sky was falling, African Americans are committing all these crimes and doing all these things. There's no question that, to your point, Judge Rushing, that we're limited in our ability because we've had no discovery. There's no question, from Frances Hagen's papers, there's so much smoke here, okay? Frances Hagen, when she released the documents that she released, showed that there was a hate algorithm, showed that some internal things that we didn't have access to. For us at this moment, based on all the facts that we know, and based on the 9 people that died that day in that church, we, as a public, are telling this court what Facebook did is not publishing within the intent of what publishing was.
Mr. Saran, if we were to agree with you, what would you tell us, or how would you suggest that we address Saran? What would you say, how would you suggest we deal with that opinion?
I don't think Zoran's wrong on its face, but I think what we're dealing with today is different than what we were dealing with in 1997 when Zoran happened. At that time, Facebook did not have the ability to psychologically profile you. They didn't have the ability at that time to share information with Google. They didn't have the ability in that time to understand the biochemistry of the brain. The amount of information that is gathered on each one of us and how we're manipulated by this company is something that we need to know more about. And we cannot, look, hate crimes are up in this country astronomically since 2014. This has got, sorry, Judge.
I'm sorry.
This has got to stop. And it's not going to stop until we take some of this blanket immunity off. Let us get to discovery, and then they can make their argument in summary judgment. But this coming up here and arguing that because of a law in 1996 and a ruling in 1997 gives them blanket immunity to do all the crazy stuff they're doing, that's wrong. And I agree, Judge Diaz, the Congress ought to do something. But I don't know, I'm from Birmingham, Alabama, and I don't know of a more dysfunctional place than Washington, D.C. right now. So I'm putting it on you, Judge. Yeah, I think you need to act.
I think Judge Keenan has a question.
Yeah,
Yes.
it seems to me that you're arguing that the intent of Facebook has a bearing on whether it is a publisher within the meaning of Section 230. You keep saying they intended to do this. Their goal was to maximize. And do you agree with me that your argument seems predicated on their intent?
Absolutely. They want to make money, Judge. They're a corporation, one of the biggest corporations in the world, and they want to make money.
Right.
And that's all they care about, and we have given them, I'm sorry.
And I don't mean to interrupt you again, but I'm trying to think, how does this court write an opinion with your point of view? So you're
Well,
saying that you have to establish a certain subjective intent, and then that creates lack of publication, or you're not a publisher if you have this in your mind, but you are a publisher if you do the exact same act, but you don't have that in your mind. You see what I'm saying?
Yes.
How difficult it is.
Yes, I understand it. I would tell you that, sure, if we like ceramics and we're trying to learn about ceramics and we go and search on ceramics and we want the internet provider to be able to give us some information on different ceramics and we want the search engine to work the right way, and we get that. That's not what we're talking about here. What we're talking about here and where the line gets drawn is that as a company, as a social media company, if they go to the point of manipulating your brain purposefully, only in order to make sure that you stay on the site, regardless of the psychological damage that they know can occur to you, because they just want to make money, that's not protected publishing. That's avarice, greed, inhumane, incorrect, and this country and our public cannot tolerate this anymore. So that's my message today, and I'm sorry for my forceful nature. The surgeon in me comes out a lot. So I appreciate the opportunity to talk. I'm glad to answer any other questions.
Thank you very much, counsel. We appreciate your argument. We very much appreciate the arguments of the lawyers here this morning on this very interesting and difficult case. We'll come down and greet you and then move on to our second case. The second case is 23-0257, In re Rendelman. Ms. Scheckinger?
Good morning, Your Honors, and may it please the Court. My name is Caroline Schehinger, and I represent the movement in this case, Mr. Scott Rendelman. The only question before this Court is whether the Supreme Court's recognition of a mens rea element for a true threat crime is a new rule of constitutional law that is retroactively applicable. The government concedes that it is. Instead, the government asks the Court to reach beyond the gatekeeping requirements and deny Mr. Rendelman's authorization motion to file a successive petition by resolving disputed questions of fact. Your Honors, that would create a new gatekeeping requirement that Congress never stated, and this Court's cases foreclose. Not only that, the government asks you to leap to the conclusion that the counterman error had no difference in Mr. Rendelman's case, an unprecedented inquiry at this gatekeeping stage, even though because of the trial court's rulings, Mr. Rendelman never had the opportunity to take the stand and testify about his mental state and introduce his psychological evaluations into evidence. And even though the prosecution stressed over and over during its closing arguments that Mr. Rendelman's mental state was irrelevant. The Court should grant Mr. Rendelman's authorization motion and allow the district court to decide in the first instance on a full record whether the counterman error had an impact on Mr. Rendelman's case. I'd like...
Sorry to interrupt. Counsel, do you see any ground on which a court of appeals could sort of go past a bit beyond the gatekeeping function that you, I think, accurately described and refuse to grant a COA on a case that just is so patently without merit? Is there any scenario where you think that's possible?
Yes, Chief Judge Diaz. This court has held that there is one circumstance where it can do that, and that would be where the claim is, quote, plainly barred as a matter of law. That's the standard this court articulated in the Vassal case at pages 270 to 271 of the opinion. And in other words, the standard is sometimes there's a legal claim that faces such an insurmountable legal hurdle that it would make no sense to authorize it. It was plainly barred as a matter of law. In Vassal, it was because the movement simply waited too long to file it. There was no dispute at all that the movement did not comply with Congress's statute of limitations. And the court went to great lengths to emphasize that it was not resolving any disputed questions of, quote, fact. It was resolving a narrow legal issue. Other times this court has done so. Hubbard would be an example, Hubbard as well, Irby as well, would be where the new rule of law that the claimant invokes does not actually apply to his case as a matter of black and white, clean rule of law.
Do you think that plausibility has anything to do with this analysis?
No, Your Honor, I don't think so. And I think the court can look directly to the Williams decision where it decided this issue for the very first time. And it interpreted the statutory phrase prima facie showing in 2244 B3C, and it held, consistent with every other circuit to consider the question, that it refers only to whether it is, quote, reasonably likely that the movement satisfies the gatekeeping requirements. And here, the government concedes that those gatekeeping requirements are met.
So to the extent that some of our subsequent cases have suggested a plausibility requirement, you think that that's just inconsistent with Williams?
I think it is inconsistent with Williams.
Or maybe you don't agree that we have suggested that.
Well, I think there is tension in this court's cases. I'll grant that. And I think you can look to footnote 4 of the Graham opinion, where this court said there's some tension in this court's cases, but we follow the earliest in time panel decision to the extent there's any conflict. And that's Williams. But I do think
Graham took on Irby directly, didn't it, in that footnote 4?
Yes.
I mean, and that's what you're saying, but it seems to me that Irby is more than a little bit of attention, because Irby is talking about possible merit, and that does go to plausibility, doesn't it? So, I mean, in order to agree with you, we would have to then say that the footnote 4 in Graham resolves any issues that existed prior between Irby and Williams, and that we are now bound by that.
I don't think so, Judge
No?
Keenan.
Why not?
And that's because in
I mean,
Irby,
I'm not saying that's a bad way to go. I'm just saying that, in fact, it might be the correct way to go. But it seems to me that that is your argument, because Irby does, it seems to me, creates more than tension. Irby quite frankly talks about possible merit, which does suggest plausibility.
certainly, Judge Keenan, I think that you could say that Irby is inconsistent with this court's cases, as this court noted in Graham, and you can revert to Williams. But I think that even if you look at Irby, this court should still grant Mr. Rendelman's authorization motion, and here's why. If you look at that phrase that the government points to in Irby, in the very next sentence, this court stated that what it was really concerned about was when it used the phrase, mere citation to a new rule is not enough to satisfy the gatekeeping requirements. And so what Irby was concerned about is the situation where a movement purports to invoke a new rule, but if you look, just as a matter of black and white law, the movement does not actually rely on that new rule. So in Irby, for example, Irby sought to bring a claim based on the Supreme Court's decision in Johnson, invalidating the residual clause of the Armed Career Criminal Act as unconstitutionally vague. And the court did not allow that claim to go forward because, as Irby put it, this court's precedents and also the Supreme Court's precedents, quote, made pellucid that Irby's second-degree murder conviction counted as a crime of violence, or rather a violent felony, under the force clause.
So what you're really saying is the possible merit language in Irby had nothing to do with its analysis, that its analysis was that it was precluded as a matter of law by virtue of the determination whether second-degrry retaliatory murder is a crime of violence.
Absolutely, Judge Keenan. And I think that your opinion in the Winston case also reached the very same conclusion. The government there tried to argue that whether the movement would be successful on the claim should bear on the merits, and should bear on whether the court should accept the gatekeeping petition. And this court, Justice Keenan, you wrote the opinion, said not at all. That is not part of the gatekeeping inquiry, and that is an issue that the government should hash out in its briefing with the movement before the district court. I think there are good reasons for all of this. If you take a step back and you look at Congress's statutory scheme here, for one, under Section 2255H2, which is the provision at issue here, Congress set forth 3 discrete, readily assessed criteria. Is there a new rule? Is it retroactively applicable? Could the movement have brought the claim before? And you can compare that, Your Honors, to subsection H1, which is about the authorization of an actual innocence claim based on newly discovered evidence. In subsection H2, the provision here, nothing in that inquiry remotely even hints at any consideration of the facts underlying the movement's claim. By contrast, in subsection H1, Congress used the words clear and convincing evidence. We have to presume that Congress meant what it said when it contemplated a merits-type analysis as part of the actual innocence inquiry, but not as part of the authorization of a new rule of law claim.
You know, sometimes we've referred to it as this question as whether it would be pointless or frivolous to send it to the district court. And I know you're drawing a distinction, which I think is evident in our application of the statute between like something being foreclosed as a matter of law versus requiring a merits inquiry. But imagine in this case, I mean, here you're saying a harmlessness analysis doesn't arise to that standard. But imagine here that he didn't get proper jury instructions about subjective intent, but he did actually, there are statements on the record from the defendant saying, I knew that this was threatening and I intended it for it to be threatening. So there's instructional error. The counterman new change in the law clearly applies to his case, but we can see in black and white that he has already admitted to that element, even though the jury was not asked to find it, or the judge, the fact finder, wasn't asked to find it. Would that be something that we still send back to the district court, or can we say, that this satisfies the gatekeeping requirement, but it would be frivolous to send it back?
I would submit that those facts are not at issue here,
Right.
but just even
That's hypothetical.
answering your question directly, Judge Rushing, if it was a matter of undisputed fact, the defendant got up and testified that he intended for the statements to be threatening, and the court could simply look to that undisputed question of fact, then yes, possibly you could hold that the claim would be plainly barred as a matter of law.
Well, how's that? I mean, the analysis is still harmlessness. It's still the Brecht, did it have a substantial and injurious effect? But we're just changing the evidence. We're just changing how sure we are harmlessness is satisfied.
Well, just to go back to the conversation that I was having with Judge Keenan, I don't think it's appropriate to go down this road at all, given this court's decision in Williams and Graham. And I think the questions that you're asking, Judge Rushing, just go to the factual difficulties that can be presented in any case. There's a reason that the substantial and injurious effect standard applies not at the gatekeeping stage, but when a court of appeals and then the district court is reviewing the actual merits of the claim. And I think it's really important to remember that there are actually two gates here. Congress intended the court of appeals to be the first gate, to conduct a preliminary analysis. And that's evident in the statutory phrase prima facie showing. Then, Congress also provided in Section 2244B4 that the district court is supposed to conduct a more in-depth inquiry. It's not bound by the Court of Appeals determination, and in fact, the district court can deny the authorization motion based on the movement's inability to satisfy the gatekeeping requirements. Another key point I would mention here is that under Section 2255H, the district court is required to hold an evidentiary hearing unless the existing record, quote, conclusively shows that the movement is not entitled to relief. And so the 10th Circuit put this really elegantly in Ochoa when it explained that all of this comports with the respective roles that trial courts and appellate courts play in our institutional system. Trial courts gather facts. They find evidence. That's why Congress has that requirement of conducting an evidentiary hearing. By contrast here, the crux of this case is the evidence that never made it into the record. And I want to highlight that at every juncture of this case, Mr. Rendelman tried to introduce evidence of his mental state. But the trial court, applying then correct law, precluded Mr. Rendelman from doing so. In fact, Mr. Rendelman rescinded his decision to testify in his own defense, and that's at JA 48 through 52, after Mr. Rendelman moved to dismiss the indictment on the basis that the government did not show a, quote, true threat, and the district court reiterated, once again, that a defendant's subjective mens rea was irrelevant. So Mr. Rendelman did not take the stand. In addition,
Can I ask you a question about that, the mens rea issue? Judge Rushing gave you a hypothetical that had a set of facts which seemed pretty clear on their face to suggest that the mens rea requirement would have been met. But the government's position here is that it wasn't necessary that Mr. Rendelman have any specific intent. It was only necessary that he consciously disregarded a substantial risk that his communications could be viewed by others as threatening violence. Does that somehow alter the calculus with regard to the import of the mental health evidence?
No, it does not. And that's because whether a defendant consciously disregarded a substantial risk is a standard teeming with fact questions that I think Mr. Rendelman's psychological evaluations would bear on. And so I don't think that just because there's not a specific intent requirement, that means that Mr. Rendelman does not prevail. But as Judge Keenan mentioned earlier in the discussion, I think that we really should stop with the gatekeeping requirements themselves. And I'd just like to briefly conclude, Your Honors, by emphasizing that the government hasn't pointed you to a single case remotely like this one, where it was conceded that the Supreme Court established a constitutional element of a crime, a brand new element, and it was also conceded that that new rule applied to the movement's case, and yet the Court of Appeals denied authorization after closely parsing the facts. The government's silence is telling, and the court and Mr. Rendelman asks that you respectfully grant his motion. Thank you.
Thank you, counsel. Mettinger, welcome back. Round two.
May it please the court, Your Honors, my name is Jason Mettinger, and I'm here on behalf of the United States. So, Your Honors, the government submits that the Supreme Court's decision in Counterman versus Colorado is retroactively applicable on collateral review because it is a substantive rule that does narrow the scope of 876C. Nevertheless, we do ask this court to deny Mr. Rendelman's request to file a successive habeas petition because he simply has not averred a plausible claim to relief. And Your Honors, if I may, I'd like to start with that plausibility claim, because that works into some questions that Chief Judge Diaz and Judge Keenan asked about essentially, should we even consider plausibility here? The government's view is that we should, and you can. And you can do that because Irby did it, you can do that because In re Thomas did it, and you can do it because a number of cases, Hubbard, Thomas.
What about Graham? It seems to me that was kind of the elephant in the room in your brief. There was no discussion of Graham in footnote 4. And Graham was an obvious effort to resolve these conflicting principles. And why didn't you deal with Graham?
So apologies, Your Honor, if we didn't, but I'll take the opportunity to do so now. In our view, Graham didn't close the door to this line of inquiry, and it couldn't. And the reason it couldn't is because you have to look at what 2244 is. It is a permissive scheme. So this court may grant a 2255 successive petition, but it need not. And so this court has expounded upon its discretion. What can we consider in this construct? And it said we're not limited just to 2255H's stringent requirements. You can go beyond that. And the case that I think speaks the best to that is In re Phillips. This is at 879 F. 3rd 542. It says surely this gatekeeping function in 2255H is necessary. You got to do that first, but it's not necessarily sufficient. And so this court can consider other considerations. This is what this court said in Phillips. And so respectfully, I think Graham indicated what we're considering on 2255H, that yes, this gatekeeping function considers whether they've satisfied that first standard of whether it's a new rule. But the Phillips case, the Irby case, the Thomas case, it says this court is empowered in its overall gatekeeping function to consider other considerations, and that includes plausibility. And so this court has said, we need not blind ourselves to reality. That was In re Thomas. We should not engage in an exercise in futility. That's In re Vassal. And then again in Phillips, it said it's sufficient but not necessary but not sufficient. So this court is empowered to go beyond just 2255H. That's our argument, and I think the case law bears that out. But I also think that's a good result.
Well, let me ask you, the question that I asked counsel in the prior case. So you're writing the opinion of the court that says that a degree of plausibility analysis is permissible. Under what circumstances? How would you confine an opinion like that? I mean, it looks like Graham in footnote 4 was really trying to shut the door on what you're advocating now. And so how do you open the door back up again when you're writing this? It seems to me what you're doing is emphasizing the end point, and you're saying any reasonable person would get to this result, so you should. But how do you get there? How would you write that? How would you articulate that? Because it seems to me you haven't really given us any guideposts.
Right, so I think in all of these cases, especially this one, we're going to have a fact-specific inquiry because you see what the new rule is. It's not always going to be like Vassal where it's a clear demarcation of it's barred by the 1-year bar. Here, I will admit that this is a little different. But I think you can look at
We'd
these.
have to make a factual finding then? Is that what you're saying? In order to reject a petition that otherwise on its face meets the requirements of the statute?
Well, so it meets the first parts, again, but our view is it has to meet this plausibility standard too, and that's a standard that's going to be driven by the facts. And so here the question is, as Chief Judge Diaz put it, we're now in this counterman world. And can we say, based on what we have in the record, that Mr. Rendelman was at the very least reckless to the idea that the hearers of his threats were going to interpret them as such? And we don't really have to get into a lot of machinations there because he says himself, these are threats. He says it in the record. He says it as an opening statement. He says it in the letters themselves that these threats will continue until I'm released. That is exactly what he says. He is saying they're threats. Now, there's a second.
What are you saying then? The opinion would say, as a matter of law, he consciously disregarded the likelihood that these threats would be taken seriously?
Yes. So the court could rule for the government by saying just that. But I think you could go even further and say it's not just even the recklessness standard. He has met the intentional standard. He has said himself in the record, I am intending these as threats. Now, there's a second level to that, and I think it gets to the point my colleague mentioned about mental health reports and things like that. What he really wanted to get in was the idea that he was doing this for another purpose. He admits he was making threats. He was doing that purposefully, but he had another purpose for doing it. He was doing it to show a protest. And, Your Honors, in our view, that is not relevant to this new counterman standard. Once he admits that I'm making a threat, it's game over. And it's game over because that's all we need to meet under counterman. And if I could give you just a quick example, it's like a bank robber, right, that says, I'm robbing the banks, but I'm doing it because I want to get food to feed my family. The law is not concerned about that second part, that I'm doing it to feed my family. The law is concerned that he's intentionally robbing banks. And so here Mr. Rendelman is saying, I am making these threats. And yes, he's doing it for this protest purpose or what have you, but these are threats. And so I think we're well past counterman here. The record just shows it indisputably. So why would we send it back? But even if we are in this reckless world, even if that's just the standard we meet and we didn't have those admissions from Mr. Rendelman, we still get there. And we still get there because of the language of these letters, which I think Judge Russing was adverting to. When they say, I will take my axe and chop you up to pieces, there is no world in which that is not reckless to the idea that the hearer is going to see that as a threat. Let's look back at counterman, the things that counterman was struggling with. This idea of like, well, I'll kill you if you don't, show up within 5 minutes and make me wait. Euphemistic phrases. We are light years from that. The other thing we have to
question about the record and whether or not the record could be expanded to include other evidence of mental health evidence, because you made the point that it appeared the only thing that Mr. Rendelman was interested in alleging was that this was a protest and he would continue to do it. But your colleague on the other side suggested that there are other mental health issues at play here Do you think the record is limited? Could they not present other evidence of mental health issues that might negate the mens rea element here?
So there might, but again, our view is they're not going to get anywhere close. It doesn't matter what they put in.
Well, that's
He
your
is-
view, but that,
He, I guess what I would just say, Your Honor, is, he has said himself on the record, I'm going to send these threatening letters. He's recognizing and admitting that they're threats. I'm going to keep threatening you until I'm released. Under counterman,
suggests that there's something seriously wrong with him as a matter of his mental health.
so maybe, Your Honor, but again, I think that's different from counterman. That's getting into sort of competency to stand trial and things of that nature.
Well, it may also get into the issue of intent, right?
So I don't think so. Again, if you look at just the standard that counterman enunciated, again, all he has to do is be reckless to the idea that someone hearing that might consider that a threat. And we're there.
My question, piggybacking on Chief Judge Diaz, though, is what's the rush here? I mean, this case may well be a giant loser for Mr. Rendelman when he goes back to the district court. But where there is a factual component as to his intent, why would we rush here and just stamp it as case closed when the district court's very capable of looking at the extreme statements that were made and then going on to to make factual findings regarding what he has shown regarding his intent and lack of conscious disregard, if possible? Why would we hurry to shut the door here?
So, Your Honor, you're not wrong about that. The district court certainly could handle this, and we respectfully submit it would handle it in short order. So there is no rush. But again, I think there is a plausibility standard. This court's gatekeeping function, I think, has to mean something, and it has to mean that, as this court has said, we're not going to engage in futility. And if this court thinks we're not in futile land, we're much closer, certainly the result then would be we're going to send it to the district court. No question there. But in the government's view, we are so far removed from this. We are in futility land in terms of what he has said. And again, if the court disagrees with it, the district court can decide it in the first instance, and that's fine. But we think on this record, it is pellucidly clear what Mr. Rendelman was doing because it came out of his own mouth. He said, I'm threatening people. This is what I'm doing, and I'm doing it for these reasons. So we just think that there's no daylight there. Counterman at the end of the day just helps him absolutely nothing. There certainly are cases maybe where counterman could help defendants who are charged with this charge, but this respectfully is not that case. And we have the record here. We know what he said. We know the letters, I think, speak for themselves. So that's the government's position. The other thing I'll just point out real briefly back to the plausibility standpoint, I do think my colleague does admit and has admitted here, but also in the reply brief, that certainly this court can wrestle with these issues. There's lots of cases that say we can at least take a cursory glance at the merits. So I think the court can do that here. Again, the government's view is the court is empowered, and the court is empowered to look at this claim and see if it meets this plausibility standard. We respectfully submit it does not. And so that's our basis for saying that we respectfully ask the court to deny the petition here.
Thank you, Mr. Ettinger.
Thank you, Your Honor.
I just want to start, Your Honors, by saying a few words about the standard that this court should apply and then turn to the facts. So I think everyone is in agreement that the standard here is whether it is, quote, reasonably likely that Mr. Rendelman satisfies the gatekeeping requirements. He does. I think you could write your opinion in those terms. Even if the court were to take a, quote, cursory glance at the merits, which some of its opinions have used that language, you would say that Mr. Rendelman's claim is not, quote, plainly barred as a matter of law. That ends there, and the court should grant Mr. Rendelman's motion and allow the district court to conduct the harmlessness standard. A few words about the facts, Your Honor. The government just ended by saying that you can just look to the letters themselves, and that will tell you everything you need to know. Counterman itself rejected that argument explicitly. The statements in Counterman that the defendant made, he made them to a local musician that he had no contact with, no familiarity, suggested that he was stalking her, and he said things like, "You must die. Staying in cyberspace will kill you." The only evidence that the government introduced at trial were those letters. The Supreme Court said that was inappropriate. It reversed because it held that the First Amendment requires the government to prove a mens rea element. And the Supreme Court acknowledged that there will be some circumstances where the government, quote, cannot prove what the defendant thought. And the Supreme Court said that's part of the cost-benefit analysis here. We need to have sufficient breathing room for First Amendment freedoms. I think, Judge Diaz, as you were pointing to, there are psychological evaluations in the record, or that weren't in the record, rather, because Mr. Rendelman never had the opportunity to introduce them. And I would just point to the government's own statements. This was at the sentencing hearing at JA 139. The government called Mr. Rendelman an enigma, a conundrum, inexplicable on so many levels. This is a case where the evidence that never made it into the record is really telling, Your Honors, and you should allow the district court to consider that evidence in light of the evidence as a whole. We respectfully request that you grant Mr. Rendelman's motion.
Thank you, Ms. Scheckinger. Ms. Scheckinger, I note that you're court appointed. On behalf of my colleagues and the entire court, I want to thank you for taking on this case. Mr. Rendelman's position was ably presented here today, and we're grateful to you for that, and also appreciate Mr. Mettinger's able representation of the United States. We'll come down and greet both of you and move on to our final case. Please be seated. Our final case is 23-4633, United States versus Belcher. Ms. Trodden, whenever you're ready.
Thank you, Your Honor, and may it please the Court. I'm Erin Trodden on behalf of Joshua Belcher. At Joshua Belcher's trial, the district court abused its discretion in prohibiting him from introducing evidence of two events: his father's prior felony conviction and his arresting officer's subsequent traffic stop and false accusation of another driver, Stefan Johnson. By excluding this evidence, the district court prejudiced Mr. Belcher's ability to put on a defense.
Can you move that microphone a little bit closer to you? There you go.
Is that any better? We'll try that. First, with respect to Mr. Belcher's father's prior felony conviction, the district court should have allowed him to introduce this evidence as evidence relevant to why Mr. Belcher would falsely confess that the firearm was his in order to protect his father, and second, to explain Mr. Belcher's father's actions at the traffic stop. The government's evidence in its case in chief showed that the truck that Mr. Belcher was driving, where the firearm was found, belonged to Joshua Belcher's father, Roy Linwood Hairston Jr. The government introduced the registration with that name on it. There was also testimony that that was his truck. Mr. Belcher, therefore, sought to introduce evidence in the form of evidence of Roy Linwood Hairston Jr.'s prior felony conviction for marijuana distribution. In excluding this evidence, the district court essentially applied the wrong gatekeeping standard. Without addressing Rule 104B, appears to have treated it as a fact of conditional relevance, but it applied a much more stringent standard than Rule 104B and Huddleston actually require. So all that the district court needs to do in determining a fact of conditional relevance under Rule 104B is to determine whether there is evidence that a jury could find by a preponderance of the evidence that this conditionally relevant fact has been proved. Instead, the district court required affirmative additional evidence.
Well, it seems that, though, when you look at Rule 104B, it talks about proof must be introduced sufficient to support a finding that the fact does exist. So where is there proof that Mr. Rendelman knew about his stepfather's conviction?
Mr. Belcher, Your Honor, yes. There is circumstantial evidence of that, and this court and courts generally accept that circumstantial evidence of knowledge is usually the evidence that we have of knowledge. And this court, for example, in the Grubbs case, attributed knowledge but based on the relationship of people, based on the relationship of crewmen on a boat. Similarly, courts will look to knowledge based on action in conformity.
Right, but doesn't your argument essentially come down to the fact, well, he was his parent. He must have known that about this long ago conviction. And how is that, under the rule, evidence sufficient to support a finding that he did know?
It's slightly more than that he was his parent. It's first that he was his parent, second that he was his employer. And so you have two close relationships. Third, you have the phone call that's in the body cam video where you see Mr. Belcher talking to his father on the phone and calling him dad or daddy. And you can see that there is a closeness in that relationship. There's also Mr. Belcher's statement to Officer Clark at the end where he talks about, "This is my dilemma." And that is consistent with him knowing about this felony conviction, knowing and trying to figure out what to do. There is sufficient evidence under the extremely low standard that the court needs to apply. This court in United States versus McLam admitted evidence of, I believe it was prior structured transactions, simply because it said the circumstantial evidence makes it plausible that the defendant engaged in these prior structured transactions.
Do you accept that premise that that you had to prove that Mr. Belcher knew about the felony conviction? I thought there was an argument that on the one hand, it would help explain why he confessed to a gun that's not his, but that you had another argument that it would also help explain why the father has not claimed the gun, he didn't testify, he kind of ignored his son at the traffic stop, and that's independent of the son's knowledge.
Absolutely, Your Honor. And that is the second issue that the district court really didn't address at all at this and sort of glossed over. But the jury knows that this is Mr. Belcher's father's vehicle. And so a jury looking at this, given Mr. Belcher's defense position that that's not my gun, is going to think, well, if it's the owner of the truck's gun, if it's his father's gun, why doesn't his father come forward? And so explaining that in a way that's consistent with Mr. Belcher's defense theory by showing that Roy Linwood Hairston Jr. has this prior felony conviction, you're correct. Independent of whether or not Mr. Belcher knows about his father's conviction, it explains Mr. Hairston's actions. And that is also relevant to Mr. Belcher's defense.
My recollection is not the best, but were those two arguments both presented to the district court as a basis for admission?
Yes, they were, Your Honor. They were both argued to the district court. I don't have the JA sites in front of me, I apologize, but they were both argued to the district court.
So the other, I guess the other problem for you, maybe certainly not insurmountable, is you gave us an example of a case where the district court admitted evidence, and that's certainly fine, but it's an abuse of discretion standard, so it's just not enough to say that the district court could have, should have admitted the evidence. There's got to be an abuse of discretion in not admitting the evidence. So what's your argument for why this evidentiary decision was an abuse?
Well, abuse of discretion, although it's a broad standard, is not a limitless one. And among the abuses of discretion are committing an error of law or relying on erroneous factual or legal predicates. So our position here is, first of all, the district court committed an error of law in requiring this affirmative evidence of Mr. Belcher's knowledge rather than looking to whether it was plausible based on the circumstantial evidence that Mr. Belcher knew that. But separate and apart from that, and going to Judge Rushing's question, it also relied on erroneous factual predicates by simply failing to address or to recognize the relevance of Mr. Hairston, Joshua Belcher's father's response to this, and how this conviction explains why Mr. Hairston would not claim the gun. Mr. Hairston isn't just someone else who's, around or off the street. The fact that he is the owner of this vehicle is extremely relevant. The jury knows that. And so the jury will wonder, based on Mr. Belcher's position, why wouldn't he claim it? And so this is something that is substantial to Mr. Belcher's case. For those same reasons, jumping the gun a little bit, but because I know the government has raised this error was not harmless. The real problem for Mr. Belcher has, he has to be able to address these negative facts. The fact of his confession and the fact that the other person whose gun this could be isn't doing anything with it, isn't claiming it. And this evidence allows him to do that in a way that explains the government's evidence in a way that's consistent with his theory. Absent the evidence of Mr. Hairston's conviction, the jury really doesn't have a way to explain Mr. Belcher's confession or his father's actions in a way that's fully consistent with his theory. Trial counsel certainly tried to, but absent this evidence, they really were not able to sink their teeth into it in a way that the jury had tangible understanding that there was a problem with Mr. Hairston.
The fact that Mr. Belcher did confess, does that somehow alter the analysis as to harmlessness?
No, it doesn't, Your Honor. In fact, I think that the fact that he did confess is one of the reasons that this error is not harmless, is because this error goes directly to addressing why he would confess and to addressing why the jury may have reasonable doubt about that confession. And so being able to address that is substantial and necessary.
Well, that may
his
go to the
defense.
first theory as to why the evidence should be admitted, but then the alternative theory for the explanation for why the gun was there, that doesn't seem to me to be as compelling when you've got a confession in the record.
With respect to that, the jury will still be able to say, juries have to weigh all of the facts, and so they'll look at the confession, but they'll also look at where did this gun come from. The jury can then take that confession in light of the other evidence regarding Mr. Hairston's conviction. So even although I admit that it is most directly relevant to his confession, even with respect to Mr. Hairston, the government doesn't clear the harmlessness threshold. They have to show beyond a reasonable doubt that a reasonable jury, that this evidence had no impact on the jury's decision, and we submit that they don't clear that threshold. Just touching on the second issue with respect to the 2020 traffic stop of Stefan Johnson, I don't want to spend too much time on the facts, but the government's description of the video evidence really doesn't do justice to the fact that there is nothing anywhere in the video that shows the firearm in situ in the car. There are pictures of the firearm in the car. You can see the officer reaching around in the car, but you never actually see the firearm found. And so the video evidence does not foreclose Mr. Belcher's argument that there is reasonable doubt as to whether Officer Clark would have planted this firearm. That said, the evidence of Officer Clark's false accusation of Stefan Johnson of resisting arrest is relevant to his character for truthfulness under Rule 608B. He falsely accuses Stefan Johnson, not once, not only when he initially begins this, I'm not sure how to describe it, but this essentially assault on Mr. Johnson. But if you watch through the remainder of the video after that, when Johnson's already in the car and the officers come and they say, what's Mr. Johnson under arrest for? And Officer Clark says, driving suspended and resisting arrest. So after he's already cooled down and he's no longer in his emotions, he's still making this false assertion that he's resisting arrest. And as the government notes in their brief, he's subsequently charged with resisting arrest. And so this false accusation is very relevant to, it's a specific instance of conduct that's very relevant to Officer Clark's truthfulness. And Officer Clark, because he is really the witness that the government depends upon to put this firearm in the vehicle, his truthfulness is very much an issue. Being able to impeach his truthfulness by cross-examining him on this topic would have been a substantial piece of the defense, and the district court erred in preventing him from introducing this evidence, or more properly, in offering this cross-examination of him.
I mean, the two acts, though, are fairly different, right? Wrongly accusing somebody of resisting arrest and then planting evidence, those two don't seem to line up quite squarely.
Well, as you recognized, Your Honor, in the Sterling case, in order for something to be 404B evidence, it does not need to be exactly the same. There need to be substantial similarities in, I think, time or place or manner of action. Now, those similarities are here. There may be some differences, but there are relevant similarities as well in terms of these being black drivers stopped for driving violations while Officer Clark is by himself without any other officers around. And those are really the relevant factors here, whether or not it goes to the smell of marijuana or because he had a broken taillight versus because he was driving suspended. The relevant factors for this evidence go to the dynamic between these individuals and, with respect to the 404B evidence, Officer Clark's intent to use this to fabricate a charge or a piece of evidence against these individuals. I see my time is up.
Thank you, Ms. Troughton.
Thank you.
Mr. Jones?
Good morning, Your Honors, and may it please the Court. I'm Jonathan Jones, and I am here on behalf of the United States. Unless there are specific questions from the Court, I'd like to begin with the father's prior conviction that was excluded and then move to the evidence about the subsequent traffic stop involving Mr. Johnson. Beginning first with the prior evidence, the evidence that was excluded about Mr. Hairston's prior conviction. as Appellant noted, the evidence that they had was simply circumstantial, and it was speculation about what somebody in that situation might know. They pointed to the fact that they were employers, but there's not really a reason to suspect that you would know anything about your employer's prior criminal history, the fact that they were family. It's not necessarily true that you would know about something wrong that a parent did years before you were born. And what's important here, I think, is the standard of review that's applicable. As Chief Judge Diaz noted, this is an abuse of discretion. So in this situation, the fact that the district court disagreed about what we could speculate somebody in this situation would know does not constitute an abuse of discretion. Moving to the second part of why
Did the district court initially admit the evidence?
Yes, so the process was that there was initially a foundation authentication issue raised. The district court seemed initially amenable to that, ultimately changed its mind, decided that the evidence would be admitted. During a recess, did some additional research, came back and concluded that because there wasn't sufficient evidence to find that.
But that wasn't an argument that was raised by the government, right? That district court kind of figured that out on its own?
The government argued that it was not relevant. The government did not specifically say that the absence of specific evidence about his knowledge of the prior conviction. That is true, Your Honor. Nevertheless, I would say that the fact that the government argued that it was not relevant would satisfy any sort of waiver concerns that might exist here. The government argued that this evidence was not relevant, and the court explained in its ruling that it was not relevant because there was not this conditional relevancy requirement that had been met in this case.
Why do we even need to get to conditional relevancy? Why is 104 implicated? I mean, do you agree that if the gun belonged to the dad, that makes it slightly more likely that the defendant didn't know about it? So does that move the ball at all to say the gun belonged to the father who owned the truck?
Your Honor, so I agree with the statement that if the gun belonged to the father, then it's likely that the son, or there's a reason to believe the son may not know about it. But that's not what the evidence would show. The evidence.
Well, right, but then the next question is like, well, then would the jury wonder, would it be helpful to the jury, would it move the ball at all to have evidence of why, if the gun belonged to the father, right, why the father's not saying so, right? Isn't the rule for relevance is really, the bar is very low. And it seems like the fact that the person who the defendant claims owns the gun might have a reason not to claim it would make it relevant.
Your Honor, so I disagree that it would make it relevant under 401. And while the bar for 104B is relatively low, the standard under Rule 401 is very clear. It must make a fact of consequence more probable. And the fact that Mr. Belcher's father, Mr. Harrison, has a prior conviction does not make his ownership of the gun more probable.
It makes it more probable that he wouldn't claim the gun. You don't have to win your whole case with every piece of evidence. You just have to make one fact of consequence, not even an element. It doesn't have to prove an element. It has to make one fact of consequence on which other facts may rely more probable.
Respectfully, Your Honor, I would disagree that it makes it more probable as explaining why he wouldn't claim the gun, because he wouldn't claim the gun if it was not his. And so what we have here, to get to any...
Wasn't that the defense's whole argument in closing was, this is the father's gun, and it's because it's stolen, which the government told you it's stolen, and that helps explain why the father wouldn't claim the gun because it's stolen and maybe there's a problem with having a stolen gun. But that's the whole argument, is that the jury would find it compelling to have a reason why the dad's not claiming the gun.
Your Honor, that was certainly the argument in the defense's closing. And when we get to the issue of harmlessness, I think that the fact that a very similar argument was made weighs in favor of harmlessness here. But to get to your point about relevance, the only way that they structure their relevance argument is assuming first that the gun is his. And then they say that this fact is consistent with a narrative that you can tell about the gun being his. But that fact is also consistent with a narrative about the gun not being his. And if the standard...
that's not the standard for relevance. It's like, could this be consistent with both sides' story and therefore your evidence can't come in? That's not the standard.
Respectfully, Your Honor, the standard is that it has to make a fact of consequence more probable. And if the fact is consistent with two narratives, equally consistent with the two narratives, and only one of them supports your story, then it is not making that story more probable. Our position is that the fact that the father had a prior conviction.
Government all the time, and this comes in when defendants try to agree to facts so that they don't come in front of the jury, right? We want old chief as raised, and we say, well, the government's entitled to tell a whole story. The jury's going to be curious about all these other details, and so the fact that the defendant agrees to certain elements are met doesn't mean the government can't introduce evidence about them. Seems like the defendant is also entitled to tell a whole story, and facts can be relevant to telling the whole story, even if they don't, only favor, one outcome.
So respectfully, Your Honor, I would say that there's a distinction between a relevance issue and an old chief problem. Old chief typically doesn't deal with whether something is relevant to proving something the government would have to prove. It's just whether it's still relevant if it's been stipulated to, and whether the government still needs it to tell a story.
Right,
so
but
it's
the premise is that telling the story, facts that help you tell the story are relevant.
Your Honor, I agree that is true. In the old chief situation, the underlying facts the government would use actually move the case forward in terms of making it more likely the defendant committed the crime at issue. In this case, I don't think the fact actually moves the ball forward in a way that satisfies Rule 401. So it's true that they can tell a story using that fact. I don't disagree with that, Your Honor. But I think the problem is that fact is not critical to the story that they want to tell, and so it doesn't actually make that story more probable. And if they can't make the fact of either the false confession.
Is that the relevant standard, has to be critical?
The relevant standard is that it has to make a fact of consequence more probable. And if this fact is merely consistent, then I don't think that it is making the fact of consequence, which is either a false confession or his father's actual possession of the gun, more probable. What we're looking at here, and when we strip it down to the question as to what is relevant, is does the fact of a prior conviction of his father make it more likely, make it more probable that his father actually owned and possessed that gun? And while you can tell a story where those two facts are together, where the fact of his prior conviction is part of a story as to his father also owning the gun, I don't think the fact of the prior conviction makes it more likely or more probable that his father actually owned the gun. And if it doesn't make that fact more probable, then it doesn't satisfy Rule 401.
Well, you might have a harmlessness argument, right? That they offered, there could have been two alternative reasons why the father didn't claim his ownership of the gun. One of them was presented to the jury, but one was excluded.
That's correct, Your Honor. And I do think that there's harmless error in this case. And the appellant has noted, I think in the reply brief, that there's a distinction between these arguments, whether the gun was stolen or whether, and that's why the father would have had a problem possessing it, or whether the father had a prior conviction, and that's why it would have been problematic if he possessed it. But it's worth noting how similar that those arguments are, and so how useful the defendant's actual closing argument is as a proxy for whether this is harmless. The defendant argued that Joshua Belcher, who knew that the gun was stolen, would have understood it to be problematic for his father to own the gun, to possess the gun, and so would have had an incentive to claim the gun. The jury did not buy that. The jury was out for about an hour and 7 minutes and came back and convicted him on the basis of his confession and the video that they watched. The video itself is pretty clear evidence of what happened here. And I think that when we look at the harmlessness standard and we think about what a rational jury would have done on this evidence, even assuming that defense counsel had this piece of paper with Mr. Harrison's prior conviction, and they could have argued, in addition to the gun being stolen, Mr. Belcher may have wanted to protect his father from the fact that his father was not allowed to possess a gun. So he had two reasons for wanting to, or there were two bases why his father would be in trouble if he owned that particular gun or possessed that particular gun. I don't think that that moves the needle enough to think that this error was actually harmful and would have impacted the jury's consideration. We have a very useful proxy of how the jury thought about this case and what a rational jury would have done, because they had an argument about why Josh would have lied to protect his father from legal culpability and legal liability, and they were not persuaded and they didn't buy it. They had specific evidence that the truck was the father's. They had specific evidence that the gun was stolen and that Joshua Belcher knew that. They had as much evidence for that as they would have needed to have for the question about whether he was protecting him from possessing a gun as a felon, and the jury did not find that compelling. As a result, what we have here is a situation where this error was not harmful.
So but that argument relies on the premise that somehow the two arguments are equally persuasive or not, right? One can be more persuasive than the other to a jury.
Your Honor, I would say it relies on the fact that the two arguments are very, very similar. In both situations, you have an argument that Mr. Belcher had an incentive to falsely confess in order to protect his father from legal liability. And the fact that those two arguments are very similar, and I acknowledge that there are distinctions there, but the fact that they are so very similar gives us a very useful proxy for determining what a rational jury would do, because we know what a rational jury did in this context with a very similar argument. So given that, in addition to the evidence that we have, which is again a specific confession on tape and an entire traffic stop on video where the jury can evaluate what the officer did, they can evaluate what Mr. Belcher did, they can evaluate the entirety of their interaction, and whether something seems weird or strange or problematic with that confession. And after watching all of that and considering that, the jury found that Mr. Belcher was guilty. And they were not persuaded by this idea that he would have been incentivized to falsely confess to protect his father. Since that is the bucket of evidence that we have about this case and what we've seen that the jury was going to do with that evidence, then I think it's not difficult to conclude that the failure to include this prior certificate, this prior piece of paper that shows the conviction, would not have changed the jury's analysis here. Had defense counsel been able to make the very similar argument, although distinct, but the very similar argument that Mr. Belcher had an incentive to protect his father, the jury, on the strength of the evidence, and for the same reasons that they found the stolen gun argument not to work, they would have found that argument not to work and would have found that Mr. Belcher was guilty of possessing the firearm. Your Honors, moving briefly to the question about unless there are additional questions about the exclusion of the father's conviction, I want to move to the question about the exclusion of the evidence related to the traffic stop with Stephon Johnson that occurred a year later. There's a handful of bases that the appellant has raised for why this could come in. And I think none of those satisfy the relevant standards, and as a result, the district court's decision was correct. Beginning first with 404B, I think the biggest problem here is that the way that the appellant has phrased this is as modus operandi evidence, and that they want to bring it in to show a pattern of behavior on Officer Clark's part. I think the way that they have framed this and tried to bring it in very clearly implicates the idea of a propensity or a character argument. They have suggested that there's a pattern of how Officer Clark behaves with young black men, and because he behaved in a certain way on one occasion, there's a likelihood that he would behave the same way on a subsequent occasion. That is very clearly impermissible under Rule 404B, and so would not be permissible for that reason. In addition, they've suggested that they could bring it in to show that Officer Clark could have planted the gun. I think there is no evidence in the case to suggest that he planted the gun, and I think more importantly, the subsequent traffic stop with Mr. Johnson does not show a likelihood or a proclivity or an intent to plant evidence. The fact that somebody gets upset, loses their temper, loses control, and as part of that accuses somebody of resisting arrest and charges them with resisting arrest is very distinct from deliberately premeditating planting evidence on somebody. The video here, there's a suggestion that the video does not exculpate Officer Clark because you can't fully see him pulling the gun out from under the seat. But I think when we look at the entire context of the video, it's difficult to find any basis for concluding that planting evidence could have occurred here. For example, before he pulls the gun out, you can very clearly see on the video him put his phone down and take a photograph. And those photographs are in evidence. That's JA 428 and 429, and you can see the gun nestled under the seat there. When he first notices the gun, you see him sort of briefly lean over and look under the seat, and at that point, Josh Belcher is looking right at him, is standing a few feet away and looking at him. Shortly after he handcuffs Mr. Belcher, another officer arrives on the scene. So the entire context of the video, this idea that he would have had a stolen gun on him ready to plant on whoever he happened to pull over, just doesn't hold any water. And the idea that because a year later he lost control, he lost emotional control during a traffic stop and engaged in misconduct, which we've acknowledged is what happened, does not suggest that a year earlier he was going to be ready to plant a gun on whoever he happened to pull over. And so the video here, I think, clearly rebuts any suggestion that he was liable to plant evidence. But more importantly, the subsequent traffic stop with Mr. Johnson does not suggest that he was likely to plant evidence.
So one of the concerns with allowing that kind of evidence is that it turns the case into a mini trial on something that is at best tangentially related. And I get that, but credibility of a witness, truthfulness, reputation for truthfulness, that seems to me to be always relevant. And there's a distinction between allowing a defendant to bring in extrinsic evidence of 404B evidence and simply allowing a defense lawyer to cross-examine a witness with respect to specific incidences relating to truthfulness. So why wasn't it an abuse of discretion not to allow at least the questioning?
So, Your Honor, turning to Rule 608 and the specific instances of untruthfulness. So the issue here is, I think, that the Johnson traffic stop does not actually qualify under Rule 608 as an incident that shows his character for truthfulness or untruthfulness. And the reason is that it is not appropriate to take a small slice of the entire situation out of context and then say that that slice is representative of the person's character. In this situation, if you watch the video of the traffic stop of Mr. Johnson, there's a situation where Officer Clark is about to arrest him. Mr. Johnson pulls away, and that's when Mr. Clark clearly loses his temper. And he loses control, and he starts shouting at him, giving him different commands. Mr. Johnson attempts to comply, but does not fully comply. And so in the heat of the moment there, Officer Clark says, "You're resisting arrest," and then afterwards follows through and charges him with resisting arrest. I don't think that the fact that Officer Clark lost control in that moment, was interpreting what was happening as him resisting arrest because he was not complying, because he was pulling away when he was trying to arrest him, shows that Officer Clark has evinced a character for dishonesty. And I think that's particularly true when the entire context of the situation and the fact that afterward he was disciplined, he acknowledged his mistake and what happened. That again,
Your colleague on the other side says that maybe that's so, that heat of passion response might be excused or at least understood, but that he later repeated the same lie when he wasn't under that apprehension or heat of passion.
I think that the best way to interpret what happened is watching the video. He interpreted Mr. Johnson's conduct as qualifying as resisting arrest because he was so upset, and that interpretation stayed with him during the course of the later proceedings.
Well, that's
when he
one
decided
view of
to
the
charge him.
evidence, but that doesn't suggest or mean that the defense couldn't question him about it.
Your Honor, I think the fact that that's one theory of the evidence combined with the 403 analysis that would be a part of this and that the district court did, I think would pretty seriously weigh against bringing this in. So Your Honor mentioned the concern with many trials and that maybe that's ameliorated if all we have are some examinations on, some questions on cross-examination. The problem, I think, is that if you just throw this out in front of the jury, there's a real risk that they start to fixate on, accusations and questions about police brutality, about police misconduct, and they make decisions based on emotions rather than facts. And so when we have alternative ways to look at a scenario, one of which maybe suggests dishonesty, another way does not suggest dishonesty, and we have 403 concerns about how prejudicial this is and how much it could distract a jury, then it is entirely appropriate for a court to say, I'm going to exclude that. It is certainly not an abuse of discretion, and again, I will, as we pointed out in our brief, not only is that an abuse of discretion, but this court has noted that it is a rare occurrence for this court to reverse a district court's decision under Rule 403. And in addition to that, I want to highlight how harmlessness would work under Rule 608. So it is one thing to say that introducing the traffic stop may have had a significant impact on the trial and the ultimate outcome here. And we disagree with that, and we push back on the fact that this would be a harmful error. But that argument is even stronger if all we're looking at is Rule 608 and all that could happen is a question. If all of that was excluded at the end of the day were one or two questions about a subsequent traffic stop, we don't think that that is likely to have changed the jury's decision-making here, particularly since what they had was an entire video that they could watch, the context of the video that pretty clearly suggested the gun was not planted, and the gun was actually in the truck when Mr. Belcher was arrested, and then his ultimate admission and confession to the gun at the end of the video. Given that evidence, the fact that Officer Clark may have been asked one or two questions about a subsequent traffic stop would not likely have changed the jury's ultimate outcome in this case. And so we think that, particularly if you're looking under the rubric of 608, the harmlessness argument is very, very strong here. Your Honor, I see that my time is about to expire. I want to be sure I answer any questions that the panel has before I sit down.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. The bar for relevance is low. The evidence must only have a plus value, and for evidence to be relevant, it needs to make a fact of consequence more or less significant. Here, the evidence of Mr. Hairston's prior conviction makes the government's facts less significant. That is its value to Mr. Belcher, is it takes this confession and it takes Mr. Hairston's actions, which, absent this conviction, really are only susceptible to the government's explanation, and neutralizes them by providing an explanation for them that is also consistent with Mr. Belcher's theory of the case, that the gun isn't his. And so for that reason, it is plainly relevant. It does make fact of significance the government's position less likely by explaining it in a way consistent with Mr. Belcher's position. With respect to the government's harmlessness argument, the fact that the jury didn't accept Mr. Belcher's closing arguments and arguments about this, I think should not be taken as a metric that the jury would not have accepted the arguments that he would have made had he had the evidence that he sought to introduce. The government basically analogizes by saying, having hamstrung him, the district court then, we should believe that the jury would treat him as hamstrung if this had been able to be introduced. But in fact, had he been able to introduce this evidence of Mr. Mr. Hairston's convictions, that would have gone to the jury's reasonable doubt because it would have addressed these two bad facts for him. With respect to the traffic stop, it's not propensity evidence. With respect to the 404B evidence, it really goes to Officer Clark's intent. And it's his intent to fabricate an offense. This court has recognized I believe it was Queen, but the value of willfulness as evidence of subsequent conduct. And so what Mr. Belcher is seeking to do by introducing the Rule 404, this evidence of the traffic stop as Rule 404B evidence, is not to show Officer Clark's actions in conformity therewith, but to show Officer Clark's intent. The fact that this traffic stop happened subsequent to Mr. Belcher's stop, of course, is of no moment. This court has recognized that subsequent conduct can also be admissible as 404B evidence. With respect to, the government argues that the evidence of Officer Clark's actions with Stefan Johnson really only indicate a loss of emotional control. But as the court has noted and as the video shows, it's not simply that one occasion. On multiple occasions, he accuses Stefan Johnson after the fact of fabricating evidence. And he recognizes this. He recognizes this in his subsequent discipline, where he states to the disciplinary officers that he realized he'd gotten himself in trouble. He says, quote, he was compliant. He had complied with going to his knees. I had said go to his knees. He was already on his knees. So there's really no factual issue about this. Officer Clark recognizes that he subsequently recognizes that Stefan Johnson was compliant and he wasn't resisting arrest. The district court recognizes that he wasn't resisting arrest. The government recognizes that he wasn't resisting arrest. At page 36 of their opposition brief, they say that Officer Clark, quote, wrongly accused Mr. Johnson of resisting arrest. This is obviously something that is relevant to Officer Clark's credibility, and the inability to be able to explore this was deeply prejudicial to Mr. Belcher's case, especially given the fact that, notwithstanding the government's arguments about what you think you can see, if you actually look at the video, nowhere is the gun shown in situ, and you can't tell where he gets the gun from when he pulls it out. Now, the government argues that all of this is speculation or that there's no basis for this, but that's not the defendant's issue. All we have to do is help explain to the jury why there is a basis for reasonable doubt. And all of this ultimately goes to that basis for reasonable doubt. And the government can't show, it can't meet the high burden of showing harmlessness, of showing beyond a reasonable doubt that this evidence, had it been in, would not have impacted the jury's decision. Thank you, Your Honor.
Thank you, Mr. Arden. I want to thank both counsel for their excellent arguments in this case. We'll come down and greet you and adjourn until tomorrow.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you for correcting me.